episode of Surviving the Survivor, we bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
In less than one day, in under 24 hours, the trial of Donna Adelson should, in theory, be underway with jury selection. What's up, SGS Nation? Welcome to Surviving the Survivor. This is the show that brings you the very best guests in all of true crime. We also bring you live breaking news and important updates, as we have done with this and many other stories so far. And today we're coming to you because we got early wind of yet another hearing regarding some motions just one day before the trial. As you'll recall, there was a hearing, I believe it was last week, that was said to be the final hearing, and then suddenly got wind of a hearing today in about 2 minutes' time that will be presided over by Judge Stephen Everett. And here, the mainstays of STS color commentary, the two best in the business. You've got R, the letter R, O-U-R, Timothy Jansen, the Tallahassee tan man, who is a former federal prosecutor and also a criminal defense attorney with a perfectly coiffed hair. He is here, as well as, it's, I guess, technically two words, but really only one, the professor, if you say it real fast, the professor. She's the professor emerita, University of Nebraska Law School. She used to be a member of STS Nation, and then someone said, hey, you've got a really smart law professor watching your show. And we said, why doesn't she become a best guest? And ever since, she's among the best guests. And not only that, she's from the great state of New Jersey. So, Timothy, you're the one that's been there for nearly 40 years. What do we think this is about today? Everyone thought the last hearing was the last hearing. What's going on?
Well, I think you have this motion to suppress some statements made by Donna to some inmates, which I think they did some of those hearings under seal. You still have the Donna's motion to quash the subpoena for Wendi Adelson by the defense. I think the court can resolve that in open court. And I hope he'll resolve the inmate, the new information, the violation of, the constitutional rights of an inmate by using a defendant as an agent. So I hope that will be heard in open court. Yeah, but the judge needs to let the parties know before the trial if that's coming in or going out.
I always say best guest, better community. And I told a little story on the last show that I eat a lot of junk food, particularly chocolate, and usually Hershey's bars. But since my mother after World War II, moved to Switzerland, I used to eat this chocolate when I'd visit my grandmother called Frigor, Frigor, some of the best chocolate I've ever had. What happened? Not two, not three, but more people from Switzerland reached out, and they're sending me little gift boxes of Frigor chocolate. And that is why I say best guest, better community. It's just some of the nicest people on planet Earth. Joe Patuto, I know you like the Italian chocolate, but two different motions are really at the forefront of everything right now. Wendi Adelson's attorney, John Lauro, he filed a motion to quash the defense subpoena, saying that she's only going to testify under the state's immunity, which is interesting. Suddenly, she's clamming up a little bit before having to testify for her mother. And then the second one here has to do with these jailhouse informants or informers, depending on how Joe Patuto wants to refer to it as. And so those are really the two major ones. We've also got a potential change of venue, but the judge made that clear that was only going to happen during the voir dire process. Now, keep in mind, everybody, Steve Cohen and I were supposed to be driving up, but because of this motion, we made the call. We're going to drive up tomorrow, do a show tomorrow night on jury selection, but wanted to be here for this. So, Joe Patuto, what are your thoughts on what this is all about or supposed to be about in just about a minute?
The motion to quash Wendy's testimony, I think, is really a non-starter. Not only did this come up before the judge ruled, and I believe it was affirmed on appeal, but there's really no viable constitutional claim the defense has here. Wendi is testifying under immunity from the state, and the defense will be able to pursue with Wendi on cross-examination anything that comes up during the state's testimony. If Wendi had never been given immunity, the defense could not ask any other questions they wanted to ask. And in this case, there is a piece of what Wendy's going to talk about that will be testified to, and the defense will have a full opportunity to vet that. But just as if Wendi had never gotten on the stand at all, they can't introduce other things. And the reason is the state can grant immunity, the defense can't. So if Wendi gets on the stand and says anything, and it tends to incriminate her, the state can use it in a prosecution. The other motion has a lot more to it, and that is whether the state can introduce statements or testimony from Bernhardt, the informer who's in the jail.
Say hello.
Look who it is. It's Windsor. Windsor's there. Windsor's in the house. Go ahead.
The Sixth Amendment right has attached, and there is an adversarial proceeding, obviously, because Donna's been indicted. At that point, the state cannot make contact with a defendant, initiate a conversation, unless the defense lawyer is there. The defendant can initiate a conversation, the state cannot. The law in here is really called a listening post. You can have a listening post in the jail with the defendant who can listen and report. Then the law evolved from that. So listening post is really a misnomer, because you cannot be having a conversation with someone and not participate in the conversation. So there is a little wiggle room here.
Appearances on the record.
George Solomon and Sarah Catherine Dugan for the state.
All right, here we go, everybody. This is the hearing.
Good afternoon, Your Honor. John Morrow on behalf of the witness, Wendi Adelson, and my colleague, Matthew Luca, is with me as well.
Good afternoon. I have reviewed your motion, Mr. Loro, concerning the defense's subpoena as far as placing a statement on the record. I don't know if any of the parties have a position concerning you placing a statement on the record, but similar to the other trials in this matter, I do not have an issue if you do so prior to the testimony of your client. As to the placing the statement on the record, does the state have a position?
No objection, Your Honor.
Does the defense have a position?
No position, Your Honor.
Concerning placing a statement on the record, Mr. Loro, you will be permitted to do so, or another member of your firm, before your client testifies. As to the motion to quash the defense subpoena, does the state have a position?
No, Your Honor, no position.
Does the defense have a position?
Yes, Judge.
Go ahead.
May I stay here?
You may.
Judge, the issue here and the concern that we have on behalf of Mrs. Adelson is there have been two prior rulings in the homicide of Mr. Markel. One came from Judge Hankinson, and then another one came from Judge Wheeler. What Judge Hankinson ruled is that the immunity conferred by the state subpoena extended to cross-examination, and we believe that's an accurate statement of the law. However, Judge Wheeler limited cross-examination to only what the state brings forth on direct. This is a premature at this point, Judge. We have her under subpoena, and we may want to elicit testimony from her.
Well, before we get there on that point, when she's called as a state witness and she is cross-examined, she can be cross-examined on all matters raised by the direct and on matters of bias or impeachment or motive to lie. All matters that she can be cross-examined on pursuant to the rules of evidence extend under that state subpoena.
I understand that, Judge, but our issue is, suppose that she's one of the first witnesses to testify, and suppose after she testifies, other issues come up that we know if we called her, she could rebut what has been said. It's not necessarily would be something that she would need to invoke her rights. It could be a very simple issue, and we would need her testimony. So until we go through the trial to see what happens, it's impossible for us to say, yes, just cross-examining her on bias and credibility and whatever the state has asked about sounds good in the state's case until we hear further testimony and some issue arises.
I'll allow Mr. Lawyer to make his argument, but the crux of his motion is you cannot offer this witness any protection as it relates to you calling her in your case in chief. What is your response to the written argument on that matter?
Yes, Your Honor.
Hold on, Mr. Lohr. I'm going to allow Ms. Fulford.
I'm sorry, I thought you were asking me. I'm sorry, sir.
You can make your argument in just a moment.
So the issue as to immunity, we cannot confer immunity to her, Judge. We agree with that. We can't. But there may be other issues where she could testify to something that she's not taking a chance, if you will, that she's going to say something that could be used against her in the future. There could be other matters that are raised in the trial that we simply want to get testimony from her as. She is the daughter of our client.
From the perspective of your client, I certainly understand the argument you're making. Mr. Lohr, you may argue.
Yes, Your Honor. This issue was addressed by Judge Wheeler in the second McBanawan trial. It was also decided upon by the first DCA in July 2025, when the DCA ruled that the procedure used by Judge Wheeler was entirely correct, and the subpoena in that case was quashed. It was the same issue that the defense raised, where they wanted to cross-examine my client pursuant to a defense subpoena, which conferred no immunity at all on Ms. Adelson. I indicated to the court then, as I will now, that Ms. Adelson will assert her Fifth Amendment rights with respect to any relevant question asked by the defense. So the only result of the defense procedure would be to have the client's daughter take the stand and invoke the Fifth Amendment in front of the jury. And that the court decided by Judge Wheeler that would be inappropriate. And we would ask the court now to follow the same procedure as Judge Wheeler and follow the same procedure that was upheld by the first DCA just 1 month ago.
Does the defense have any remaining argument on this matter?
Your Honor, respectfully, the issue that was ruled on or concerning the subpoena, quashing the subpoena, Ms. McBanawan did not make that argument below. She did not join the state's motion. So the first DCA did not rule that Judge Wheeler followed the proper procedure. My understanding is that the first DCA held that she had not preserved the argument.
And if I could add one thing further.
We don't have tag team motions. Yeah. Who's going to finish the argument?
Just a moment, Your Honor.
They didn't anticipate all this?
Your Honor, factually, we're in a vastly different circumstance. Our client certainly has information, knows information about her daughter that Ms. McBanawan would not have ever been able to know. And so it's our position that it's premature. The Fifth Amendment question, the courts have ruled should be done on a question-by-question basis.
So your expectation is for me to ask the question, she will make some sort of signal, I'm invoking, the jury is to be removed, and then we do this for the entire defense direct?
No, Your Honor. What I would suggest is that we get into this posture, and absolutely cross-examination may be sufficient. But if we get into the posture of needing additional, I would suggest that potentially proffering the questions, then she and her counsel can advise the court if she intends to invoke her privilege at that time.
That's the proper way to do it, actually.
Word, and then I will rule.
Yes, Your Honor. The statement by counsel was patently incorrect and false. This issue was raised by Ms. Carras in the McBanawan trial. She preserved the issue. She made the same arguments that these defense lawyers are making now. It was wholly rejected by Judge Wheeler and wholly rejected by the first DCA. And we respectfully request that Your Honor follow that ruling here. There is simply no question that the defense could ask that is relevant to this matter that Ms. Adelson, my client, would answer. She's invoking her Fifth Amendment.
All right. Having reviewed the applicable authority on this issue and also reviewed the prior transcripts on this matter that were also ruled on by Judge Wheeler concerning this same subject, I am going to adopt a similar ruling. The defense cannot give the witness immunity as it relates to any matters in which she would testify under and could properly invoke the Fifth Amendment privilege. No witness can be called to the stand simply to invoke the Fifth Amendment, as there would be no basis for this witness to take the stand and give testimony on a relevant matter that also could not affect her ability to also endanger her own Fifth Amendment right. I am going to grant the relief that is requested. If we need to revisit this issue for any purpose where the defense believes there is a line of questioning that will not go to the Fifth Amendment privilege of the witness, we will at the appropriate time. But I do believe it is the proper ruling at this point to quash the subpoena. Mr. Laurel, I believe that concludes your motion for today. Again, when it's time for your client to testify, you may place your statement on the record.
Thank you, Your Honor. Good day, sir.
To you as well. That concludes the public portion of the.
Oh, God.
Oh, dear. Excuse me.
We will take a brief break and then resume with the in-camera matters. The courtroom is to be cleared by all non-parties at this.
Wow. Short and sweet. That was under 15 minutes. And you just heard the other matters, the one with the jailhouse informant or informer, that is going to be taken up in camera, meaning without cameras, meaning behind closed doors. The only thing that we were able to hear today is what you just heard, which relates to quashing the defense subpoena. So Tim Jansen put it in English. Basically, by the way, Sarah Catherine Dugan is there alongside of Georgia. The two haven't been together, but it's fight week, as they say in the UFC. And so they're both there. Zellman and Jackie Fulford, both present. The state has nothing to say about the quashing. The defense did. And they pointed to two prior rulings by judges, Hankinson and Wheeler, who ruled in favor of John Lauro and his client. So just break this down in English. What just happened?
Well, the government can give you immunity. They give you a subpoena, you have immunity. They're forcing her to testify. Wendi doesn't want to testify in any courtroom, but they give her a subpoena. She has to testify. She's subject to immunity. I did this with Brian Winchester. When Brian Winchester was going to testify, I went to the courtroom with Judge Hankinson and said, Judge, my client's going to invoke the Fifth. This is outside the presence of the jury. He's given a subpoena. I said, Judge, I understand that. My client will take the Fifth on cross-examination because the defense cannot give immunity. He goes, I am going to blend over the immunity to cross-examination for your client. And I said, fine, Judge, that's it. And that's what they're doing here, basically. On the other hand, there might be some questions that do not invoke the Fifth, right? How many times you pick the kids up or something like that, that would not be incriminating, that might become relevant for the defense, that the defense should properly do a proffer. And I don't know how they're going to do this, because if that does come up, she's not under subpoena, and I'm sure she's going to be gone out of that courtroom. How they'll get her back there if the judge changes his mind. That's the problem, because the judge has already just quashed the subpoena. So once she's done with the state, she can leave.
Yeah. Joe Patuto, to you, and you can pick up on what Tim said, but the question everyone has, especially us non-lawyers or non-law school students, is if she needs this immunity so badly and it's such a focal point, is she hiding something? I mean, I know it's a matter of law, but an innocent person doesn't necessarily need immunity, I don't think. So how do you answer that as a law professor?
Well, it's not necessarily a question of whether you need it. The issue is whether any answer or any testimony you might give might subject you to a criminal prosecution. And any lawyer would tell a client that if there's any possibility whatsoever, then you take the immunity because you don't want to run the risk I mean, there are prosecutions that are made where they're made in error, where the evidence doesn't support, where the evidence is weak, and she has every right to do it. It does not necessarily mean she's guilty of anything, although clearly the inferences most people would draw is that that's what it's saying, but it doesn't necessarily mean that. You're standing on your rights. You have every right to stand on your rights. What the defense is doing is really suggesting in advance of her saying anything that there may be an invalid assertion of the privilege by the defense, that there are things she could testify to that would not tend to incriminate her, and they're entitled to explore it. And you can't just assert the privilege willy-nilly whenever you feel like it. You've got to be able to make a showing to the judge. Now, the judge is not going to require a lot, because he's going to give a lot of, protection to the right not to incriminate yourself, to the Fifth Amendment privilege. But you've got to have some basis for claiming it. The defense is saying they think they have questions and an area they want to pursue where there is no possibility of her incriminating herself, and that the judge needs to decide that the defense is not improperly asserting the privilege with regard to those questions. Now, Tim, it seems to me, this is not we're getting into an area where I don't know that I've ever seen case law or heard people talk about it. But if she were out there, not subject to any Fifth Amendment privilege, certainly the defense could subpoena her to come, right?
Sure.
So in the sense that they're saying there are subjects in which there's a valid assertion of the privilege, I would equate that to somebody saying that you don't have the right to assert the privilege in the first place, and they could get her there under their subpoena, and then there'd have to be a hearing in camera with one side or with Wendi and her lawyer to see if there's a valid assertion. Now, it's a big problem because the defense tends not to give a lot of information about what it wants to ask about. And if you're going to challenge an assertion of the privilege, you have to be pretty fact specific about what you're going to ask. So if this comes to pass, if it's even a possibility, it may delay in the middle of the trial. I mean, they didn't give any facts today. They didn't ask to go, in camera and talk about it. There are no facts to support the claim, except they think that the defense may be invalidly asserting the privilege.
Yeah. By the way, Tim, someone had a question.
Right.
Tim, real quick. Someone had a question about the immunity applies to the cross as well, correct? If she's given
you got to make sure it does, because a defense lawyer cannot give immunity. But here's the reality, right? She testifies for the state, and then the defense lawyer wants to cross-examine her, and she goes, "Oh, I'm not going to answer. I'm taking the fifth." Well, that's a violation of their confrontation. So you have another right that's problematic. So they don't let you do that. So if you're going to give immunity by the state, you are able to be cross-examined for bias, prejudice, and impeachment purposes. So you can't let them, you have to let them do that. I just put it on the record to make sure it was clear that my client, Brian Winchester, was not testifying on cross without that immunity going over to the defense, and Judge Hankinson ruled fine. He didn't even want me to put anything on the record. If you know Judge Hankinson, he was kind of mad I was even in the courtroom.
and Tim, is there so Fairy Glam, by the way, is asking, wait, there's no cross. I'm confused.
No, there's cross.
Yeah. And then there's this question from Eric, or a comment. Anyone who might have charges against them would be crazy to testify without immunity. And I get that. But Tim, is there any sort of, before Wendi takes a stand, is there any sort of jury instruction? Are they aware of what's going on, or is it just, the jurors are not made aware of any of this?
No, they would not be aware of any of this, and that's why they don't want you taking the fifth in front of the jury. It's confusing. There really is no jury instruction about the Fifth Amendment. You see, Perry Mason used to do it all the time, where Perry would get the guy up there, and he would take the fifth, and all of a sudden they get an acquittal. He was the one that did the murder. But this is an interesting question, Joe, right?
Mm-hmm.
Say the court has ruled squash the subpoena. The defense has not done a proffer, has not gone to sidebar. They haven't done anything to put on the record of information that they want to elicit. Right. They have waived that for the appellate record. So they can't even appeal this. And then secondly, if they do, something comes up, and they need Wendi to testify, how are they going to subpoena her, domesticate that subpoena since she lives in Colorado or wherever she lives? It's not going to happen.
Yeah, but the problem is, if I were the defense on appeal on this, assuming Donna's convicted, I would claim it's ineffective assistance of counsel not to have done these things to preserve her right to be able to cross-examine this witness with regard to testimony they think is relevant to the conviction. And if I were the judge, I would try to find a way to avoid that, and let them make whatever the showing is, rather
But
than
Joe,
get that.
but Joe, how do you? I'm sorry. How do you do that if the defense can't offer immunity? That's what I don't understand.
No, he could easily do this by telling John Laurel, I'm quashing the subpoena at this point. I'm not quashing it. I'm reserved ruling until I get a proffer from the defense.
Right.
That subpoena will stay in place. And then if I hear a proffer, I may allow the state to call her. That's what should have happened.
Right. I agree with you.
Tim, how common or uncommon is this? This seems pretty complex here.
This is very complex stuff. I don't think either lawyer thought about that. I don't think they preserved the record. I don't know if Donna has an appellate lawyer already working with her, but they would have done that. They'd have said, Judge, we ask you not to quash the subpoena. We ask you to reserve ruling. We won't mention any of this in our opening or in our trial, but we want to keep her under subpoena so that if we come and do a proffer later, we can get information that's not invoking the Fifth. We can still call her. That's what should have been done.
Tim, I think you're being a little kind. You know, this issue is
I
coming
try
up.
to be kind.
Well, I know, but you should be able to project out to protect your client and to protect the record. And I don't think they did. I don't think they did a particularly good job of it on an issue that I think maybe, at least theoretically, is important to them. They didn't even mention that their issue is it may be an invalid of assertion of the privilege. They skirted around it, but they didn't say it, crisply and precisely, pointing to, the scope of the privilege. I think they could have done a better job with this. I agree with you.
I think what happens if she gets convicted, a lawyer, when they get to the ineffective assistance counsel, will come up with the arguments I made and say, why didn't you ask the judge to reserve? I think they did miss the ball. I think they did drop it. And I think it could be considered ineffective counsel because they may need Wendi to fill in a gap that could help, that doesn't invoke any Fifth, and now she's gone.
Right. And, and again, why they didn't, maybe they don't want to say it in open court, but why they didn't make a record for it, at least under seal. These are the kinds of questions we want to ask. We can't predict all of them because we don't know yet how the state's case is going to proceed, but this is the area, and we don't think there's a valid assertion of the privilege here. They had the chance today, and they didn't do any of it.
Joe, this is a perfect time for an ex parte in camera with the judge. Many lawyers don't understand that. They don't know how it works, and the court would be in a good position to do that. I think the court felt a little worried about the position he was doing because he said no, then he kind of backtracked, right?
He did.
Because he understands the significance that they can't call Wendi as a fact witness for Donna.
Look at this. Tim and Joe just going not at each other, but just they're fired up. It is it's fight week, as they say in the UFC. Annie K here.
You like to see a lawyer, whatever side you're on. Even if you have a stake in the game, you'd like to see a lawyer do the best job possible of making the case for either for the state or for the client. That's how our system works. You don't want to prevail, even if the defendant is guilty. I just don't want to prevail because the defense did an inadequate job or didn't do the best job that could be done.
Yeah.
We'll see if they think about this and file a motion to ask the court to reconsider and keep the subpoena in place, and they'll provide a proffer or an in-camera. We'll see if they do that. Maybe because of what we just said, they'll do that.
Yeah, a lot of new members. You got Amy Cranston here. For those who are not familiar with Survive and Survivor, if you've been living under a rock, we forgive you, but we do a live panel show like this every night, Monday to Friday. This is a mega trial coming up for us, and then we do a live show Fridays as well. Question here from Ida Shaw. So will Wendi testify for the state and be crossed by the defense, but not called by the defense? Just to clarify, Tim?
That's a pretty good summary. That's exactly what's going to happen. They're going to call Wendi, and then she's going to be able to be cross-examined about whatever she testified and about impeachment and bias, and then she'll be free to go. But remember what happened last time. They had to call her back to impeach, and they had to call Wendi back. Well, she was still in Florida, and the subpoena was still in place. So I'm sure if Georgia is as clever as she is, when that witness Wendi gets done, the judge will say, is this witness released? Georgia's going to say yes. And the defense then should say, no, judge, we want to keep her under subpoena.
Wow. Annie K here to the professor. What happens if Wendi lies in a provable way? Wouldn't that negate her limited use immunity? What about that, Joe Patuto?
Yes, if it's provable, the grant of immunity it gives you immunity to what you testified to and anything that can be derived because of what you said. But there are conditions to it. One of them is that you testify truly. Two, you have to testify fully. And if she leaves things out or she can be proved to have lied on the stand, then the immunity drops.
She can also be prosecuted for perjury.
Yes.
And perjury in a capital offense, she can get up to 15 years in prison.
Jeez. Tim, to you from Conch, as in a conch shell. You just sort of said the opposite. Won't the state hold Wendi after her testimony just in case, like a Charlie's trial? But you're saying that the state will release her, kind of calling a bluff on the defense. Is that what you think is going to happen?
I think they will release her because Georgia's smart enough. She doesn't want Wendi to be able to come back in and help the defense in any way. She knows she lives out of state now, so she's going to release her. The reason she was called last time was, I think it was because, remember about the dinner, about the birthday party, and she was called, and then Lacoste testified, and he impeached her, so they called her back in for impeachment.
Joe, this seems to be the case in almost every trial to a degree, but are they already headed, and by the way, thank you, Lauren, for the super chat, are they already headed to an appeal before the trial even starts?
Yeah, I've been listening to Tim on this, and I've been trying to work in my head what I might do, and I agree with him that Georgia, if she releases her, preserves this trial. But in the back of my head, I'm saying, maybe better to permit the other evidence to come in than to risk the appeal. That's a tough calculation for a lawyer to make. So this one looks like it might be. The one that we're not hearing, the one they're doing in camera right now with regard to the informer, is really, I think, a big deal because the law with regard to jailhouse informers is pretty clear. And I was thinking about it this morning that unless the evidence is nothing like what the defense brief says it is, and it's pretty clear, if I were the state, I might very, very clearly think about not using it anyway. They've got a very, very strong case, and to put that one in, which if in fact on appeal, the appellate court looks at it as a really viable issue, might bring a conviction down in another trial. So whatever's going on there, I hope the evidence is very clear, or that the judge says, no, you can't use it. Or even if the judge says, yes, you can use it, the state thinks hard about using it when they've got so much else already.
Yeah, and Tim, that brings us right to our next question from Jonathan Nye, who's not the science guy, but might be related to the science guy with that name. Why is the other motion not being discussed in open court? This is the one about the jailhouse informants.
Right.
So much we don't know about the new investigation because there's so many redactions. Could this new investigation implicate Wendi?
Well, as a disclaimer, I want to say on the record that the new witness that has been involved was my former client. And I can't go into attorney-client, but I can tell you this is a very dangerous situation. And Joe is right. The law is clear. When you're represented and you're in jail, the government cannot send an inmate in to question that inmate. That becomes an agent. You can't do that. It violates their Sixth Amendment. But if an inmate is in there and they got charges and they want to get a deal, sure, they're going to listen and talk to Donna all they want. And then when they get that information, they can go to the state. The state should then not send that witness back into the jail cell. That is bad policy. it looks like, now I don't know if the arguments are true because I don't know, but if the government sent that witness back in there, there's clearly an argument they're an agent. Now, whether they're passively listening or if they're questioning makes the big key. Now, apparently this new witness said the person was not just passively listening. That would then make that inmate an agent. Now, this is only based on what the defense filed. The better practice, and I can tell you my practice, I would have the witness get all the information that they could before you notify the state, because then they're not an agent. And then if you go to the state and say, hey, listen, this witness has information, you do not go back. Because then you got that fine line you always got to get over, right, Joe? You keep it clean. And I don't know, it doesn't sound like it was clean in this case.
Did she even have a lawyer then, Bernhardt, to be able to give her that advice? That's unclear.
Well, she would have, because she had a VOP pending.
I
And
guess that's
apparently, so if she couldn't afford one, she would have had a public defender.
Yeah. Forgive me and forgive Lou, but has Charlie's attorney publicly said anything about him taking the fifth yet that we know of because of the pending appeal?
No, and I'm amazed. I would have said, I heard Tim say this the other night, and I agreed with him, that I can't imagine Charlie testifying, but they transported him. And I also can't imagine them spending the money to bring him down if they didn't think there was a reasonable chance he was going to get on the stand. So I have no idea what's going on, but I cannot imagine his lawyer telling him, hey, it's okay to get on the stand and testify.
At the risk of having Groundhog Day again, I've been informed that whether Charlie testifies will be to be determined. Not for sure not going to testify, but still may testify.
Do we know what the TBD relates to? Like what does it revolve around?
I think maybe that he's already testified that it's not going to change. Charlie's testimony is not going to change. And if that testimony can help Donna, which I would assume it could, because it's going to be right, the same defense somewhat, then it could be helpful to Donna.
But he's also going to be impeached. He's convicted now of the crime.
Sure.
Guys, what you're looking at here, we put this out on Patreon to Patreon members for the first couple of days and now released it publicly. This is, we've got people everywhere, and someone sent us this. This was Charlie en route this weekend from South Dakota, somewhere on the way to Tallahassee. And you can see he's got 3 body men, not 2. He's in what looks like a smock, but it's a shirt. And I reached out to my buddy Lenny DePaul, who is, if you know anything about fugitive manhunters, he is the fugitive manhunter. He told me that Charlie would typically be with 2 guys, but in this case, he had 3 guys with him. This is a regular TSA line at an airport. Someone snapped this photo for us. He was sitting apparently in the middle seat. Once he got on, his legs were shackled, his hands were shackled, and this is how they transported him. It was not on Con Air. Whoever the lady in the blue was going on that same flight, she had the privilege of being on the same flight, I say that sarcastically, as Charlie Adelson. So he did not fly Con Air. Tim Jansen, I mean, I know you've had clients transported. How unusual do you think it is that Charlie was just taken in a regular plane from South Dakota out here to Tallahassee? He looks a little, let's put it this way. He's not flying the way he used to fly with the Gucci bags and all the rest.
Well, I'm sure it was a financial decision. It was probably cheaper than getting a private plane or getting Con Air from wherever he's in South Dakota to Tallahassee. So they figure we'll buy 4 tickets. We'll get the last row, and there'll probably be an air marshal on the plane also. The pilot would be notified. They probably have weapons on them. I would take it they're U.S. Marshals, because I don't think a sheriff out of Dakota can carry a gun on the planes. Or maybe FBI.
I think it was Marshals, I believe.
Yeah.
And I sent this to my pal Lenny DePaul, who is just a badass human being, and he used to chase down bad guys. That's his entire career. He says this is fairly typical. And you can see the guy behind him, the guy in front of him with a hat, and then apparently there was a third guy. But you can see Charlie's a pretty FYI. Charlie has a waistband on with cuffs. They use leg irons while he's seating. There is no nonstop flight from South Dakota to Tally, so he had to have a stopover there. But Charlie's not a small dude. I mean, he's like 6'2", 6'3". He's not, and I mentioned that when I saw him at trial last year, and he's thick. I wouldn't say he's a muscular guy, but he's a thick guy. And it's good to see that he's got the guys with him doing what they got to do. Imagine that job. You got to fly these guys around the country. What a job that is. So Tim Jansen, just walk us through now. Now that this is in camera, this is now about. So for those who don't know, basically there are some jailhouse informants that are saying that they got information, and there was an investigation that possibly Donna was trying to get some testimony from some of these people. It's kind of a convoluted little story, but what's going on behind these closed doors right now, Tim? I mean, what kind of questions is the judge asking?
Well, the judge is smart, and the judge is going to say, Georgia, do you really want this evidence? Do you need this evidence? Because the case law and the facts, if true, are not good. And do you want to risk a conviction, getting it appealed, if I let this testimony come in violation of her Sixth Amendment? That's a real problem. Sometimes experienced prosecutors, they don't care about the appeal because normally they're gone or it's so old, they don't care. But Georgia will care. Jack will care. A lot of money was involved in this. A lot of witnesses. The Markel family deserves justice. They don't want to have another trial. This is a tough issue for the judge, and it looks like it probably was one of the better motions by the defense.
By the way, tomorrow night we have 2 or 3 of the country's best known jury consultants who are going to come on and talk to us about the jury consultant process for the Dan Markel trial. Now, Joe Patuto, last time they famously brought in Josh Dubin, who's this very high priced New York City jury consultant. But Joe, this time it looks like they're not doing that. I mean, this is Josh Selman and Jackie Fulford, who are Josh is from Miami, but has been working in Tallahassee for a very long time. So it looks like they're just going to rely on the smarts of the Tallahassee population. I mean, what are you expecting tomorrow during the first day of jury selection? Will get up there in the afternoon tomorrow and be doing a show in the evening on the jury selection process for the first day.
First, let me say, I don't know whether they're using a consultant. They're clearly not going to use a consultant the way Daniel Rashbaum did, but often lawyers use a consultant behind the scenes. They may even do some mock juries, and I don't know whether that's going on. Well, what I expect tomorrow, because of what Judge Everett said back at that last motion hearing, is they're going to start out on the issue of the pretrial publicity. And he said he said morning, afternoon, as though it was going to take 2 full days to get at that. I'm not sure it will, but I think that's where they will start. He said he would go down to where the jury pool is to do that. And then they would go into the kind of voir dire we're more familiar with, where the lawyers get to ask some questions, and they may ask some of the same questions or pursue the publicity questions more. But they're going to do typically what you do in these trials, try to vet whether somebody has a bias, in one way or another. And they probably are coming in with some feel for the type juror they want, whether it's profession, whether it's age, whether it's race, marital status, so they probably have some notion in a general way of the juror they want, and then they will use their instincts and the information that they might have gotten from the consultant to try to get to the jury that is most helpful to their side, both state and prosecute and defense.
Yeah, shout out to Christina for this, and shout out to Ida Shaw JD for a very generous super chat. We missed you, Ida Shaw JD. Where have you been? Tim Jansen, how long ago did the jury summons go out for these jurors? What kind of pool, what size pool of jurors should we expect at courtroom 3G tomorrow in the Leon County Courthouse?
I think there'll be like 300 to 500. And I think they do them in waves. Like they'll send when I was part of the jury pool in Mag Bono, well, they would put them up there, and I think about 75 at a time, and then you go from the big room into the courtroom, and then they individually call you back into the chambers courtroom, because last time, as you heard on the appeal, they had jurors talking to one another about what they heard in newspapers and podcasts, which were possibly tainting the rest of the jury panel. And the judge wasn't in there. And I don't think there was anybody monitoring that. I think you'll have somebody in there this time telling the full room, do not talk about the case. Just read a book or paper. You're not allowed to talk to each other.
The judge already made that clear, Tim. No talking at all. No talking.
Okay.
They could
Right.
read, and he's going to have extra bailiffs in there to police it.
Right.
To the law professor from Bill Davis, love Bill. Joe, Tim, is there any legal mechanism, professor, where Charlie could testify without negatively affecting his appeal?
I'm not quite sure what the question means by legal mechanism. He can get on the stand, and let's say it's the defense that calls him, and they can narrowly tailor the questions that they ask, and the state won't be able to go well beyond what the questions are that are asked by the defense. But he can't testify for the defense and then refuse to answer the questions that the state might impose. And he's got to get on there in the same way Wendi, if she testifies, is available for cross-examination by the defense, at least to the full scope of what was done on direct. Charlie on the stand is in the same place. He just can't go, and he can't pick and choose what he wants to answer to when he's up there. If he gets a question from the defense, he has to answer it. And if the prosecution wants to impeach based on those, he has to answer those too.
Shout out to KB Dale, who says it's the first time they're catching us and are enjoying the show. Appreciate it. If you appreciate the content, please hit the like and subscribe button. And I would agree with this. I would say best guest, better community. STS Nation is most definitely a family. Yeah, unlike some of those other content creators who like to sow division. That's not what we do here. We come together. So I love this group of people. It is awesome. Look at Jared Ross. I was not called for jury duty this week, but he was called to send me a photo just now. Jared Ross sent me a picture of the Court TV transmission truck. Court TV is in the house in Tallahassee. They are ready to broadcast this trial. So game on. Speaking of game on, Tim Jansen, it was this time last trial ago that Steve Cohen and I, and this is one of the reasons I sort of waited around today. I'm going to get booed for asking this question. What could possibly go wrong at the 11th hour right now? Is there anything stopping this trial from moving forward tomorrow? There's no more Dan Rashbaum.
I think we're on go. I think everybody's on go. The issue he talked about in camera had to do with the inmates. So I think everybody's ready to go. Witnesses are here. I think it's a go. Unless something cataclysmic happens. As far as a jury consultant, they really wouldn't need a jury consultant. They have the transcripts of the jury consultant, Josh Dubin, doing his. So they can just read what he was questioning, but I'm not sure they want the same jury that Charlie had. It didn't work out so well. And I can guarantee you that they did focus groups or a mock trial on that tablet with Donna before the trial, because remember, she wanted to move back to Wakulla because she couldn't get the tablet anymore and communicate with her lawyers. I'm sure that they were doing some kind of focus groups so they know exactly what kind of juror they want.
Looking at the comments here. Joe Pachuta, there was a comment earlier. Harvey Adelson, if you're a betting woman, will we see him in the courtroom as soon as tomorrow for jury selection? Will her bride, Donna's bride, or groom, not bride, groom, will he be there? Will he be there to support her through thick and thin?
I don't know whether he'll be there for jury voir dire, but I think he will attend this trial. He was at one of the hearings. I understand that he's got some apartment or somewhere there in Tallahassee, so I would be really surprised if he's not there.
And what about Wendi can't really be there if she's testifying. Rob can't really be there if he's testifying. Tim Jansen, who else are you? I mean, you think we'll see Donna's family members? And do you expect Rob Adelson to testify here?
Well, that's good. I think they will call Rob on rebuttal, and that's preserved by the court. What about that Dr. Graber or whatever his name was that was supporting the gynecological doctor was claiming all this nonsense?
The guy who comes into our chat and says everything
Yeah,
positive about Donna.
I'm
Yeah, I
sure
know.
he'll be here. And my understanding was that Harvey was going to be present until they had the conflict and moved the trial last time.
Tim, you think anyone tries to take a swing at me? And if they do, I might have to call Monica's husband. I don't know.
He'd be a good one to call.
Yeah,
It'll be too late. You already got the black eye.
Yeah, you're right. But I've got the bailiffs in there. I can run around behind the bailiffs.
Let's not promote violence. By
No,
anybody.
please.
Yeah. Let's not do that. Let's definitely not do that. And don't forget, it's FSU Bama. The entire city of Tallahassee is going to be gearing up for that. So Tim, I don't know. What is the 11th hour possible surprise here? If you had to pick one, what could shock the world?
I don't really foresee anything at this point shocking anybody. I think everybody's gearing up for trial. Everybody's ready. Court TV's here. Newspapers ready. Local affiliates are ready. I think, I know Monica was at the courtroom today doing stuff. I think this trial is ready to go. They're going to pick a jury and go.
I got to ask you, was Monica doing stuff on behalf of Luis today?
Monica was at the courtroom today. That's all I'm saying.
I'll say this, Monica, you do not mess with Monica. And Monica told Steve that she can't really do much the next few days because she does work with Luis Rivera. And now she has to back off while he's in town and help her client. So we respect that. But I will still somehow get over to see one of Monica's horses and give it a little scratch under the chinny chin chin. Joe Patuto, do you feel the same way about horses as you do dogs and cats? Are you a little more?
I feel the same way about all animals, domestic and not. I like them from a distance. I honor people who love them and want to pet them and be licked by them and the rest of it. But and want to walk them. And with horses, there's a lot of work to it. And I honor people who want to do it, but it is not me.
So if I gave you like 7 carrots and a horse, you would prefer not to open your hand and let the horses slurp the carrots out of your palm.
That's right, because it's going to lick my hand when it finishes the carrot. I know it, and it's not a sensation I list on my top 100.
Joe Patuto, I love Joe. Any final concerns here? And I don't know, what's your level of anticipation? We're literally less than a day away. It's hard to say that.
Well, my level of anticipation is high. I'm really ready to watch this trial. We've seen it before. We've seen enough motions to fill a living room. So it would be nice to just see it get going. And I think it will, and I think it will be interesting. There's always something in a trial that's not anticipated fully, but I agree with Tim. I don't see anything big coming that we don't know about already. And I just think it's good that we're actually here.
Yeah. Look at this, Brittany. Jeff Burlew, by the way, is one of the nicest guys you ever meet. He's also the investigative reporter for the Tallahassee Democrat. He's also he feels about cameras the way Joe Patuto does about dogs and cats. He does not like them. And so he refuses to do anything on camera. But when I see him, Tim and I can con him or corner him and get him to come on. So I'm going to try to do that because he's like a wealth of knowledge. But Brittany's saying that Jeff Burlew said that Harvey was in the courtroom today. Tim, you think that's by of his own volition, or Donna said to him, Harvey, you better be at every single moment of this trial, and Harvey showed up? What do you think?
Well, Harvey wanted to go to jail with her, remember, at the airport?
Yeah.
He wanted to go with her. So he truly believes till death do us part unless you get arrested for murder.
I just want to say for the record, if the COE, God forbid, ever went to prison, I'll go right alongside her. By the way, a personal note, I woke up this morning. The COE was holding my hand. I've had a little summer cold. I thought it was so sweet. And I rolled over to say, thank you. That's so kind. And it was my son, Judah Mack, who had crawled into bed and was actually the one holding my hand, my little son, Judah Mack. So next time, COE, you have time to look at this. Joel's such a chicken. Oh, this is because I was saying I was going to run. So that's pretty much a wrap, guys. We are under a day away. Steve Cohen and I are heading up to Tallahassee first thing in the morning. We are stopping at the Busy Bee. If you know, you know. If you don't know, you don't know. A member of STS Nation has put us in touch with the owner of Busy Bee, who I'm going to reach out to today. And it might even be possible that not only do we stop at the Busy Bee, but we meet the owner of the Busy Bee. And that to me would be just an amazing, absolute amazing experience. Joe Patuto, you're up north in the great state of New Jersey and you travel to Italy. You've never come across a Busy Bee in the Panhandle, have you, Joe?
Well, I've never been to the Panhandle, so I haven't come across anything in the Panhandle. I don't know. I mean, I don't think I've been to a Busy Bee, but I suspect I've been to stores and, places on the highway like it. Maybe not as good, but like it.
Imagine a rest area that goes on as far as the eye can see. That is immaculate. You could literally sleep on the floor. It is
Like
so
100
clean.
gas pumps.
Yeah, like
Wow.
100 gas pumps, no dogs in sight, no cats. It's meticulously clean. They sell Busy Bee merchandise. It's like I could literally move in there and be very content for the rest of my life.
Chandeliers in the bathrooms.
Oh, nice.
Why the Busy Bee does not I'm going to speak to the owner about sponsoring our show because she should. I would not accompany anyone to jail, says whatever. Okay, final question. Tim Jansen, how many days does this trial last? Does it end in a conviction?
Well, I think it's going to go longer than Dan's. I think you got two lawyers that are going to fight, and it's going to get a little ugly during the trial. And I think they will put on a defense this time, other than just Donna. I think they plan on calling a couple witnesses, and I think the cross-examine is going to be more thorough than what Dan did. So I think it'll be a little longer trial. But I think any chance she had, the flight to Vietnam is going to be the final, the final problem for her. That jury instruction is really damaging, and with everything else they got, it's going to be beyond a reasonable doubt.
One-way ticket to, I mean, God, I just can't get around that. This is the greatest name in all of YouTube, Addicted to STS. And if you notice, it's got the Canadian flag. Addicted, please email the COE, Surviving the Survivor at Gmail, so we can send you some swag. I would really like to do that. She says my husband is on his own if he goes to prison. Joe Patuto, how many days does it last? Does it end in a conviction? And I'll add one more for you. Does Wendi get indicted if there is a conviction? And that is how
I'm not going to predict how long it lasts. I will rely on Tim's judgment. He knows, he's done more trials than I, and he knows the Tallahassee scene certainly better than I. Yes, I think she will be convicted. I think there's certainly more than ample evidence to meet a beyond a reasonable doubt standard. And I have said before with regard to Wendi that I think the evidence there is enough if the jury were to run all reasonable inferences in favor of the state's case. And my inclination would be to go forward with a prosecution because it's kind of a now or never, and I'd give it a whirl. I think the state would have a reasonable belief that they could convict, which is what is necessary, sincere and reasonable belief. The only thing I would say in addition to that is if they're still interested in her, they might want to wait until Charlie's appeals have run. But, in the hope that he might then be willing to give information, but I don't think it's very likely that he would provide much information. It's possible. I think he's really angry at her. But so long answer, yes, I think she will be prosecuted at some point.
There you go. Look at this. The COE on top of breaking news. Katie McBanawa is now on the move. All the players are inching toward Tallahassee for this trial. Tim, let me ask you. It was last trial. I think Wendi was called very early on, one of the first or second or third witnesses. Do you expect the same? Or look at this also. Please get Joe a cuddly dog toy. Would you accept a toy, Joe Patuta?
Toys don't lick, so yes.
Okay, I will get you. I will get you. God, you would hate Fred. Fred is a big kisser, man. Tim Jansen, where in the trial does Wendi Adelson get called as a witness?
Well, they'll do it chronologically, and they're going to show motive and show the reason for the divorce and the animosity. So I think she's going to be very early on. And I saw one of your questions, want to know what I was drinking. I don't want them to think I'm drinking alcohol.
Oh yeah, is that wine, Tim?
This is my green tea with blueberry. It's been wonderful in my Mediterranean diet and losing my weight. So it's not alcohol. I think so. Wendi will be called early, I believe.
All I can say is I am super thrilled. I'm gonna not see Joe, but I'll see Joe on the camera. I'm gonna see Tim in person, who's a gentleman and a scholar. I've been talking to the bump man, who's Tim. He's gonna come have dinner with us.
Good.
And this is in no way a celebration, but it is a memorializing of Dan Markel and the people who were close to him and those who helped get justice for him all come together, and it'll be an interesting time. And I think we're going to end up with a conviction here. We're going to have gavel to gavel coverage, and it starts in earnest on what day is today? On Wednesday. But tomorrow night we'll be doing a jury selection show live from Tallahassee. Join us. Love you, America. Love you, Jersey. Love you, Tallahassee. Justice for Dan Markel. Next time we see you, we will see you live from Tallahassee.